El auge de la industria del streaming, la aplicación de los derechos de streaming, las herramientas y los casos principales. Gian Asencio, Directv Perú. Mark Traphagen Law PLLC, Estados Unidos. Moderador, José Roberto Herrera Díaz, Abogados, Colombia.
Bueno, muy buenas tardes a todos.
Good afternoon, everyone. Maybe for those of you in Central America, good morning. It's wonderful to be chairing this panel that is so relevant with the current pandemic, and that's the boom of the streaming industry, where I would dare say that most of us have increased the consumption of the streaming content. And where it is important to consider the rights derived from streaming, not just audiovisual, but music, video games, and even tools like this one that enabled us to organize this Congress that has been the tool by excellence, including Zoom and apps that make it possible to broadcast audio and video. Today, we're going to listen to two speakers that work with this industry, and we'll speak of the rights arising from streaming, as well as the violations of streaming rights, as well as legal discussions that have appeared. So in the panel, we're going to ask questions to each speaker, and at the end we'll leave from 10 to 15 minutes for questions from the audience. So I would ask you, if you're interested in asking questions to ask the speakers, please send them through the chat in writing so that I can chair the debate and the questions. So we'll start then with the presentation by Gianmarco Asencio, who's a lawyer, an expert lawyer in competition law and intellectual property from the Pontificia Universidad Católica of Peru. And he's currently he is the legal manager and compliance officer at Directv Peru, and he will give us his view. So, Gianmarco, thank you for the invitation in the name of a CP to participate in this online seminar, and I hope that next year we'll be able to hold it in person. So, as you're an expert in the topic, especially of piracy, I know that you gave us a talk about focusing this in the area of streaming. So you have the floor. Thank you, Jose. And I want to thank ACP for the invitation. I think it's a huge opportunity to share some ideas and criteria to discuss streaming. If you agree, I can share my screen to start with that, with a discussion. Thank you. Hopefully you'll see it well. So the topic, I'm going to focus it on informal use of contents and piracy. And I can't ignore a very important topic, that is, what have been the regional efforts to fight against piracy? You may imagine what it's like to fight against piracy in an unorganized manner. That's a titanic job. So it was very important to put together alliances that existed already since 2013. And now in my presentation, I will tell you what it's all about, who is in the alliance. And as the legal manager and compliance officer at Directv Peru, I'm in charge of that struggle. And we have a team. And I'll tell you about that partnership, because it's good to have alliances. So let me tell you who is part. There are 3 tiers. The first thing is that the operators of paid TV, we have Directv and Sky that is in charge of cable TV, of and we also have the programmers such as Discovery, ESPN, La Liga, who's a wonderful partner, and HBO, Turner, and other very important partners. And finally, somebody who is absolutely key for the technological support that are NAGRA and the Brazilian Association of Cable TV. And so NAGRA has a huge lab that enables us to be aware of the technology that is used for piracy. So it's a huge contribution, as well as the programmers too. What does Alianza do every day? Well, there are many things that we need to address fighting for piracy. First of all, a constant monitoring. We are constantly shedding light on informality. It's like putting a lamplight in a street with no light. So, and we try to predict what they're going to do tomorrow. And so we are they're always trying to be a step ahead, because the enemy is always trying to see how they can steal content. And by monitoring, I mean, we're always trying to see the servers that they use for piracy, what kind of equipment they use. And there you'll see a couple of names such as FTA or OPV. The FTA is a feeder. In some countries, they started selling equipment to as an open signal equipment, but they were used for piracy. That they entered in Peru, the footwear, and that could have happened in all Latin America. And they entered 6,000 pieces of equipment in Peruvian territory used for piracy. This is to give you an idea of how important it is to be paying attention to each space where the pirate is present. After monitoring, we have investigation and denunciation. After identifying the piracy and investigating, we contact the authorities precisely to develop the legal action that needs to be undertaken. Thanks to that, we managed to seize and we identified important cargoes of equipment, and of course there are seizes. We seize, and we can take the people to court. The pirates don't act in an isolated manner. There's a huge network of people that coordinate things regionally, and it's quite impressive. And to tell you the truth, I've seen it, I've witnessed. Alianza always gives us more eyes to be paying attention to piracy. We also, not only do we have important verdicts, but we managed to stop many pirates. Then there's a regulatory and legal initiative. As Alianza, as the entire industry, we always work hand in hand with the authority in each country. Why is it important to have this regulatory issue? Because we always check whether the regulations can always be improved. There's always room for improvement, so we take proposals for the authorities to analyze them, and according to the respect of intellectual property in each country, so that the authority may take this proposal and so that they can adopt it in the country. Why is this important? Because not necessarily are legal frameworks the best to fight against piracy. It seems obvious, but it isn't. When fighting against piracy, you may run into a lot of hurdles that you have to overcome to achieve measurable actions against piracy. That is why the regulatory aspect is so important. Fourth, we have the technical countermeasures. It is whenever we detect a transmission source that can be detected and identified, NAGRA, for instance, from the laboratories globally, they can send some commands or some kind of technology to block the source of transmission of pirate sources. That has been instrumental. It's been very useful. And that is why the technical countermeasures that we do. So we thank their work. And final, last but not least, the joint work that we do with the authority, not just in Peru, but also internationally in LATAM. This has to do with how important it is for the authorities to be as leaders of the technologies that are being used, who's using them, how they're using them, and in a hands-on way. In the trainings we share, we take the lab to the room so that the authority may see how any equipment that they bring for piracy work. What are the types of piracy, and not just in Peru, but the most important? Of course, we have the online piracy through the internet. Then we have the piracy using the so-called, the illegal decodifiers, such as the FITWare that I mentioned. There are some that are called the IPDB that are much more powerful, that you can download the piracy from the internet and you can consume the piracy. It facilitates the existing piracy. And finally, we have the typical piracy, the best known, that has to do with cable companies. I'll show you a couple of charts. In the case of Peru, just to give you an idea, there are more than 300 companies that have a concession by the state, but there are others that were never authorized. So both the ones that have been awarded a permit or others that don't have the permit, these companies, unfortunately, you'll see the figures of the country, in practice, they operate as pirates. So, when I talked of piracy through the internet, here you have two examples. It's really simple. Even if you're not familiar with the internet piracy, there are many websites or even apps that make it possible for you to have illegal access to contents. And by that, I mean the local contents. Sometimes it may be open sessions, but also international contents. Look at the programmers in these images. These are programmers that globally there are many people that have access, and fortunately many do that through pirate means, streaming. So you have cyber blocker, P2P, BitTorrent. There are many different platforms through which they can operate as pirates. And then you have a huge interest in sports. So we are going to see a bit more of information about this, but there's a great interest in sports and developing illegal contents in sports. So a while ago, I mentioned the FITWare, FTA, the decoders, the illegal decoders, and see how they offer them in the social media. They fortunately, they have already, most of them have been stopped and blocked, but they help you have pirate access. People, being or not aware of the illegal aspect, they may think that it's legal, but as soon as you turn on, it gives you access, sometimes guided or not, to illegal contents. this equipment that you see there, the trademarks are very well known, AZ Box, AZ America. This is equipment that, thanks to recommendations by, for instance, the Peruvian government, they have a restricted entry into the country because it is known that they're used for piracy. That was a great achievement. You may imagine that it implied a lot of effort by Alianza, but it was huge because the Peruvian government understood the huge impact on the national economy, and I'm sure it happens in other countries, at a tax level of jobs and the owners of contents. And thanks to the information provided by Alianza, the Peruvian government issued a restriction to prevent this equipment from being imported into the country. In addition to this equipment, there's also equipment that's the second version of FTA, that it sort of talks with the internet, and we are also working to achieve a formal restriction nationwide. So here I have bring some more examples. This is equipment that today is marketed. You can go into the internet and you'll see that it's used for piracy. And so this IPTV, that is like FDA 2.0, have already been analyzed, and we are trying to stop them globally, so to prevent them from entering the countries and damaging with their piracy. And finally, just a while ago, I mentioned the many cable companies in the country, in Peru, and I'm sure that in Latam it's similar. Many of these cable companies may not have permits, and they do piracy. The pictures that you see there are an evidence that the way you carry business here is informal. They do nothing about safety. There's no safety or security standard. And the worst thing is that it's often the case that consumers, for instance, a province in Peru, in the north of the country, Piura, for instance, it's an important department at the north of the country. Somebody that hires a cable service may assume that the company providing that service is formal, but that's not the case. Unfortunately, in Peru, most service provided like this is informally. I'll show you the figures. Here you have another picture. Look at the level. Each decoder, the decodifier that you see there, there are still companies that use the decodifiers such as the IPTV or the FTA equipment that I showed, and they connect each to draw a signal from each and to pool all the signals together with all these stolen signals, and that is sent to the clients who may not even be aware that the company is pirate. This is what's happening in Peru. Just as an introduction, by way of introduction. Thank you, Gianmarco, for the introduction. I was really surprised to hear about how for the companies where mostly they work that they have cable, but streaming may also be used to offer service. But much of the piracy, if not 70%, is through streaming. So that boom is seen not just in streaming, but also in piracy itself. But the good thing, as you pointed out, is the current effort to fight against these new violations to the copyright. We know it's a new technology, and it's important to see how the lawyers respond to those changes in technology. So in Colombia, we also have an office to advocate for the copyright, and despite the technology difficulties because of the new technology, I think that the work of lawyers has been important, and it provides tools to the governments to fight against these violations. I wanted to ask you, and I know that you have prepared this considering the Peruvian settings. So from the Peruvian point of view, what are the figures that you could share about streaming? Of course, Jose. And what you just pointed out is very important, and it has to do with what I said at the beginning and how important it is to work in an organized manner. Because sometimes if you work individually, you may have very specific victories, but being organized together is very important. And the regulatory framework in LATAM is very important, and working with the authorities. Inacopi did a wonderful job, and actually we continue to work with them day after day. The Ministry of Transportation and Communication and Hositel and the customs also, and even the tax authority, SUNAP.
IP is not just an issue of intellectual property like in the COC. It's an issue that has to do with economic taxing issues, labor issues. Every time we analyze the informality and piracy, we find that there are different aspects that we hadn't considered. As Jose said, now I will give you a brief context of Peru. At first, I talked about the Alianza achievements. Now we'll talk a little bit about figures in Peru. I can now tell you how things are organized. A very important issue, this is published by the Industry Association webpage, has to do with the penetration of piracy in Peru, that is huge. As of 2019, there are over 3.7 million people that have access to piracy. So we believe that it's about 47 to 50% of those people are informal. They have informal access to the content. This informal access to the content, as we said, of course, don't pay taxes. And of course, the owners of those rights don't receive any kind of payment. So in Peru, unfortunately, the figures are high, and we believe that they are increasing. I think that in 2020, the situation will not be the same, and I will tell you why in a minute. But it's important to see that 47% had illegal access to content. This does not necessarily mean that those who consume this content know that their source is illegal. I will move on now to the next slide. Here you can see that prepaid TV is growing less than 1% in Peru. But typically this means cable TV, satellite TV. Yes, they've had problems recently due to the level of informality in other areas. But it's not easy to grow formally in Peru, given the penetration of piracy. As we saw, penetration is doubling. Internet piracy, whether it's mobile internet, fixed internet, this situation, piracy that comes through internet, it is used illegally more and more frequently and increasingly. So, as we said, less than 1% in Peru of the people use regular TV or cable TV. Now, in terms of streaming, 83% of Peruvians hired their first streaming service this year. Imagine in the COVID context, people in Latin America confined will certainly find a source of entertainment. Of course, if they have children, this is even more complicated. We have to show something to the children. What happened in Peru, and see how important this is, that 83% of the Peruvians hired their first streaming service in 2020. This information is important. Why? Because this 80% of Peruvians are not necessarily all informal. We need to see how many of those 83% of the people that hired streaming services did it informally and how many did not. Because there is a higher access to streaming if you hire streaming informally than if you hire it formally. So we need at the private and at the public level, look at this picture to coordinate efforts to stop this. If we don't stop this, the impact at consumption levels will be huge. I hope I'm not talking too fast. These are figures that the local regulators showed. The movie and video platforms are increasing, of course. And this comes from what happens in 2018 and 2019. So, for example, in this part, you can see that there is, we see paid TV and video streaming at the same time, according to the consumption patterns that you see. This is important because probably for 2019, we will see 10.3% of the people have paid TV or streaming. We need to see how many of those had access to that kind of TV legally or illegally. In both cases, we need to see what is the source of their streaming. This is the ways in which internet has been used according to the type of connection. And here we have to watch videos or listen to videos without downloading them. We have 32%. This will probably increase. This is 2019, so it will increase in 2020. This is a fact. People people to watch or listen to video, they dedicate about half of their internet consumption to watch videos. 46%. There are other things that they do, messaging, social networks, etc. From a fixed network connection, we see that the situation is similar. 44.9% of the people use their connection to watch videos, about half. And the use of internet to watch streaming continues to increase. And here you can see the mobile connections in Peru. And here you can see what type of connection from which type of users is being used. But if we think of the impact of piracy in the next few years, it's going to grow substantially. You can see that to watch videos or audio, there is a significant increase. And to use a public cafe, internet cafe, is about 37%. So what we see that the use of internet to watch content is high, and we need to consider the internet access that people have. I think we need to emphasize what use they are giving to this and the importance of pirate content online. Of course, we need to reinforce again that consumers don't always know that they're using pirate content. There are different business models. I will only talk about this one called ad-based model. That is, the people don't pay for the content, but they will receive advertising and they will have to close it. Finally, the pirates won an advertising industry. They can put the advertising that they considered, so they have illegal content that is free for everyone, but then they can put their advertising. Not necessarily the consumers know that this is illegal and that the content is available through an illegal means. There are others, of course, subscription-based. Right now we have access to legal content, but implies subscription-based content as well. That is cheaper, but it's important to know that pirate content could be linked to subscription-based content. This enables you to connect to internet to have access to this content, or through an app. A child can download an app and they can have access without knowing to a subscription-based content. So the child, imagine when they start to do this as a child, clearly they will keep the same behavior tomorrow. I think that is important. These two are the most important, ad-based and subscription-based. This has to do with the evolution of piracy. Of course, piracy is not physical. It's not stealing a file or a disk. Everything is streaming. At the beginning, I spoke about the importance of keeping up with the pirates. The pirates are always innovating. They're always identifying or finding a way to steal content. This is why it's so important to have coordinated work between the public and the private sectors. Fortunately, we are taking good steps in this sense. Then we have the use of piracies in smartphones, in tablets. That is what is happening now. And as a consequence of all of this, it is less clear for some users when they are using official services and when they're using pirate services. So it's true that when we use content, we don't know if what we're using or buying is legal or not. This is also important. Finally, in terms of piracy, anti-piracy measures, we always think that we need to make it difficult for users to have access to pirate content, to carry out campaigns to promote official services. This is essential, keeping in mind that users don't always know that what they're doing is legal. Finally, I will show you some examples of how pirates are always trying to innovate. These are two screenshots of a signal that was pirated of Directv. This is a live broadcasting of a soccer match by Facebook. And the pirate that took the content and put it online on Facebook, maybe if you see here, you see Jape donations. This is an application, so you can make payments online. In Peru, some time ago, they have started to see these practices, that is, people that identify a content that is exclusive or very relevant. They put it on the social media. This is about 500 people. It had about 20,000 actually. So the content is uploaded, and the person at the same time is telling people to make donations so that they continue to show the content. Many times they reach that, so they can continue to watch the match in this way. In this case, we detected this, so there were not over 500 viewers. What I mean, the other example is more or less the same. It shows how the person puts a code and their phone number so they can receive donations. What I mean is that not always is a huge pirate company that we're talking about. In many countries, the pirates are just individuals. This is completely illegal, and these are a few examples for you to see that the issue of piracy is far from over. We need to continue to work at public and private level to fight piracy in the country. And finally, the most common legal platforms we can use are these: Peli Plus, Anime Fly, and sports. That is the most sought content by parrots. We have already worked with the pirates in this and with these channels to try to fight piracy in this respect. Thank you, Jose. Thank you. Thank you for the technical information in terms of the statistics. We don't know whether to be worried about this or to be thankful for the media streaming that we have to control this content. But the idea, yes, is to try to fight with these piracy actions that they use the signals to rebroadcast them on Facebook or Twitter. And the companies spend their money to try to buy the rights, and then they find situations like this. So to broadcast something on a social network is almost free because in many of our countries we have not regulated the internet services broadcasting. So they have the possibility of working freely. And even if it were regulated, sometimes it takes too long to find a solution. So they use the media and they gain significant advantage over advertisers. This is an advantage that they have in other countries that we don't have. In Colombia, for example, we are taking some precautionary measures to in a web page, we can include precautionary measures to avoid piracy. But the problem with this is the problem with blocking some signals is, and because these crimes happen everywhere, it's not easy to block the content without the legislation. So we need to try to devise international treaties so that we could fight piracy together. As you said, this is an issue that will continue to happen. And our answer as lawyers and legislators should be to keep up. I would like to thank you and the viewers again. We will have 15 minutes of questions at the end for Gianmarco. I will now introduce Mark. Mark is a founder member of Traphagen LLC. They represent clients in the United States in copyrights, trademarks, domain names, social networks, sports and entertainment, promotion, privacy, and data protection. For many years has represented Monumental Sports and Entertainment. He's the owner of the champion NHL Stanley Cup in the United States, the NBA Washington Wizards, the WNBA champion Washington Mystics, and the Monumental Sport Network streaming sports services. Other services have included Warner Chappell Music, BBC Worldwide, and Performance Rights Societies. Mark has also represented video game clients and the representation of the Digital Millennium Copyright Act and the WIPO Copyright Treaty when we speak of digital copyright. And he has advised during the implementation of WIPO Copyright Treaty. He advised the team for the subscribing countries. The treaty in the past was only about public communication, and now the WIPO Treaty included them in copyright, included the right to internet and the technical measures to control the rights of work for protected by copyright. So Mark has experience in these areas, not just practical, but also academic practice and legislative practice. He is a co-author of Cooperate Throughout the World, and he's a adjunct deputy member of the George Washington University, together with the Max Planck Institute.
I will now switch to English.
Accepting ASIP's invitation to participate in this seminar.
Well, thank you very much, Jose, for that generous introduction, and thank you too, Giancarlo, for your presentation. It was very detailed, and it reminds me a great deal of the situation that has plagued the software and television and music industries for the last 30 years. We see sort of copyright infringement use new media and new technologies, but in some ways remain very much the same. And I think the efforts by the Alianza really mirror the kind of efforts that are being made in the United States by record labels and streaming services and music publishers. So congratulations and thank you.
Thank you, Mark.
I'd also like to thank ASIPI for the opportunity to speak today. The invitation was very gracious, and I really appreciate the offer of interpretation. So thank you very much, ASIPI, and my congratulations to the program organizers.
I know that Mark also prepared some slides for us. And I would like you just to ask you to tell us about a brief background on the streaming rights in the US, and also if you can explain us about the current issues in relation to passwords that many people are also using unauthorized passwords in order to infringe and gain some on this fact. So if you can also tell us about this situation in the US.
Yes, thank you. Let me activate my screen and share it with you. Let's see. I'm going to share, and then all right. Are you able to see the screen? All right.
Yes, all right.
Good. Oh, excellent. All right. Well, thanks. What I'd like to speak today about is the perspectives from the United States with respect to the issues facing the streaming industry. The views are my own. They don't represent necessarily the views of my clients. So the first topic, it really builds upon the remarks and presentation by Giancarlo, which is to explain how exclusive rights in streamed programming are being enforced using intellectual property laws in the United States. Enforcing these exclusive rights is a particular concern for streaming services, and it implicates also the unauthorized activities by streaming pirates, as well as activities by subscribers outside the terms of service for the streaming service. Right. So let's begin with just a little bit of background that affects almost all of the countries that are grappling with this particular problem. In 1996, over 100 countries completed negotiations on the WIPO Internet treaties. 2 treaties, a treaty on copyright and a treaty on neighboring rights, in particular, a treaty on phonograms and performances in phonograms were reached. And among the milestones in these treaties was a recognition that the exclusive right of communication for both copyrighted works as well as sound recordings and performances included an exclusive right to make their works and performances available to the public, either by wire or wireless means. And that in addition to what we are familiar with as broadcasting, in which the broadcaster picks the time in which a work is available to be viewed, that the right of communication should include making works and performances available to the public at a time and a place that is chosen by individual members of the public. Essentially, this is a recognition that the right of communication included an exclusive right to communicate works and performances on demand. And this was a great milestone in both of these treaties, and that's almost 25 years ago now. It's from there that national laws and jurisprudence have been developed, and that has particular importance here in the United States. One of the interesting aspects of the treaties was that the particular language was developed in order to encourage flexibility, so that countries could implement these exclusive rights without having to make significant changes in their legal traditions with respect to copyrighted works, sound recordings, and neighboring rights. Right. That was especially important in the United States because rather than having our exclusive right described as a right of communication to the public, it has for almost 100 years been characterized as a right of performance to the public, that a work may be performed to the public via any type of technology. And so regardless of the technology or medium being used, a work or a performance or a sound recording is nonetheless being performed, which reaches back to legacy principles in the Berne Convention and other, and most importantly, U.S. copyright law. And this avoided having, to disrupt long-established commercial expectations, and it also avoided disrupting long-established jurisprudence in the United States. So, the exclusive rights that a streaming service in the United States relies on are an exclusive right to display a copyrighted work to the public, and the exclusive rights to perform a copyrighted work to the public. Display rights typically involve works of visual arts. The right to perform typically involves works that can be recited, or dramatic works, or works that can, in which a performance in a linear form is made. And jurisprudence has confirmed that this exclusive right to publicly perform a copyrighted work is comprised by internet streaming. 2 cases in the United States are particularly important. The first case was in 2014, a U.S. Supreme Court case that confirmed that the right of public performance includes the transmission of copyrighted works to the public through individualized streams. That is, transmitting a work for viewing at a time and place chosen by the viewer, the recipient of the stream. Right? In 2018, a decision that was affirmed by the Second Circuit Court of Appeals in New York, Capitol Records versus Redigi, confirmed that an audio stream is a performance because there is a playing of the song that is perceived simultaneously with the transmission. So we've had confirmation that streaming is within and controlled by the exclusive right to display or perform a copyrighted work, and that the streaming service, as the copyright owner, has the exclusive right to authorize reception of those streams. Now, in addition to the exclusive rights of display and public performance, there can also be an exclusive right to reproduce and distribute copies to the public if the streaming service creates a digital copy as a result of the transmission. And that was recognized by the US Copyright Office in a recent policy study that it conducted. Okay. So, how do streaming services in the United States control unauthorized access and copying of their programs? Well, for the most part, they typically use passwords. They require subscribers to use a password to access the streaming service. Right? There is a legal tool that reinforces the technical protection provided by passwords, and that's the anti-circumvention provisions of Title 17 of the United States Code. In general, federal law in the United States prohibits the activity of circumventing technical measures that control access to copyrighted works. Technical measures can include passwords, encryption, hardware authorizations, anything that would effectively control access to a copyrighted work and prevent unauthorized access to it. In addition, US federal law prohibits trafficking in devices or services that have as their principal purpose circumventing access control measures. Now, these prohibitions are subject to specific statutory exceptions, which are updated every 3 years in a rulemaking proceeding by the US Copyright Office. So passwords, encryption, other technical measures are one way that streaming services control unauthorized access and copying of their programs. Right? And that's reinforced by a law prohibiting circumvention of those measures. In addition, streaming services in the US use contracts with their subscribers, typically known as terms of service. Right? I'll give you, here's an example. Section 4.2 of the Netflix terms of service states that this Netflix service and the content viewed through our service are for your personal and non-commercial use only. Personal and non-commercial. That means that the subscriber cannot charge others for the for sharing access to the service. The Netflix terms of service, like many other terms of service, also provides that the password of the subscriber may not be shared with individuals beyond your household. Right? And that would seems to be a reasonable accommodation for some of the realities of the way people enjoy streaming services in their home, that reasonably they could expect to share access with other members of their families in the same household. The reality has been a bit different. let me show you. Actually, I'll jump ahead to a slide. For example, subscribers, a number of subscribers have engaged in the habit of sharing their password with people who are outside their household. And this is more than just a minimal activity. According to a report by the analyst Moffett-Nathanson, almost 1 in 6 Netflix viewers reported that they use a password that they obtained from someone outside of their household. 1 in 6 Hulu viewers reported the same, that they use a password from someone outside of his or her household. Right? That was the situation in 2019. It's likely to continue today. And there have been estimates that this password sharing phenomenon, if left unaddressed, could constitute losses of up to $9 billion for streaming services by 2025. And that, of course, affects many people. It means some authorized subscribers are bearing the cost of people who are not paying for subscriptions. It means that there is less advertising revenue available to streaming services. That means there's less money to invest in new productions. It also means there's less money to compensate other right holders, for example, music publishers, record labels, musicians, whose works may be comprised by the streaming programming. So that's one challenge. Oh, and we can go on to the other challenge. I think that I want to pause here and see if there are any questions.
Thank you, Mark. That's really interesting. And right now, this password sharing with services like Netflix is so common right now in social media, but that there are many people that are offering their passwords, and they are also asking for money for this. And this is at least in the Andean community, I have seen this behavior not only in Colombia but also in Peru, if I'm not wrong. If Gianmarco also can tell about it, but at least I know that there are some answers given by the law in order to control this unauthorized use. But yes, the main idea is that the main point is that with the pandemic, the infringement has grown in this sense a lot. And this is the other point that we were preparing for the panel about the special challenges that the pandemic have arisen because of when enforcing these rights.
Yes, thank you. Yeah, there have been challenges posed by the pandemic. One, of course, is that people are watching or streaming, which is a good thing, as long as they're actually paying for it. But there have been particular challenges presented by the COVID-19 pandemic. First of all, on the production side, streaming services and programming producers needed to curtail production of new programming last spring. That interrupted the supply chain for new programming for streaming services, and they needed to compensate for that by finding other recorded programming that had been previously produced to replace it. Since then, actually, producers, actors, scriptwriters, and crews have developed methods for staying safe while working together in producing television and film programming. So that's been good news. Nonetheless, the cost is higher because of all the steps that need to be taken. It takes more time. There needs to be additional equipment, additional safety supplies. In addition, there have been interruptions of activities in government. In particular, although the U.S. Copyright Office remains open, they have needed to make accommodations to extend deadlines for right holders to register copyright in their works. You'll remember in the United States, there is a registration system. It's not mandatory to register copyright in a work, but it is required in order to assert a claim for copyright infringement in federal court. And early and prompt registration is required for a copyright owner to qualify for enhanced remedies for copyright infringement, including statutory damages and attorney's fees. And in particular, that prompt registration needs to be made within 3 months after a work is first.
Y específicamente tiene que hacerse 3.
This affects works that will be published, meaning that they will be distributed in copies for sale, rental, or lease. Okay? Live streamed programming probably will not be published because it's never distributed as a copy. But other types of works, other types of programming that are streamed may be subject to this early registration requirement. So the Copyright Office has extended deadlines for registration of copyrighted works that would have been due after March 13th. And in addition, there have been delays and backlogs in federal court proceedings. Between mid-March and late August, all 94 U.S. district courts suspended jury trials and conducted their other proceedings by telephone or video. Jury trials are important, and their suspension means that a number of copyright cases were not proceeding until late August. Remember that copyright cases in the United States are exclusively held in U.S. district courts. And also, because of the factual circumstances presented, many copyright infringement claims are protracted and go to advanced proceedings, such as summary judgment or even a trial by jury. U.S. district courts resumed jury trials in late August, but in the last 2 weeks, about 24 of these 94 courts have suspended jury trials again because of the rising infection rate for COVID-19. So that has disrupted enforcement efforts in several ways. Just to go back for a moment, I did want to give some idea of the type of, in addition to password sharing, the kind of commercial scale signal theft that's occurring in the United States. Okay? So, like much as Giancarlo explained, there are commercial enterprises that are gaining unauthorized access to Internet Protocol television signals and also to video on demand signals. They are, misusing authorized access to legitimate streaming services to tap into the signal and to make copies of VOD programming. And they may also be circumventing the technical measures that limit access to authorized subscribers. So these commercial enterprises may not even be paying one subscription fee. They may just be hacking their way in to provide unauthorized services. Here's a couple of examples. In just the last year, one unlicensed IPTV and VOD service allegedly offered over 6,000 live TV channels and over 14,000 VOD movie titles and 3,000 VOD television series. Turning to the music streaming side, one unauthorized service made over 4,000 unauthorized sound recordings available to an alleged 19 million registered users, of which 1.5 million were daily active users of the unlicensed service. So these are infringements of streaming programming on a commercial scale, that need to be addressed through organized measures, like the ones that Alianza is pursuing. All right.
Thanks, Mark. These efforts are really interesting, and the challenges during the COVID. I know that there are big, but there are at least some positive things with this in relation to like the virtualization of justice or filings, online filings, because at least in many Latin countries, you cannot file some copyright registrations online. But I know that many offices are working with this and with the virtuality in justice as well. So at least I believe that this is perhaps good consequence of the pandemic, that perhaps in the future, if there's going to be, fortunately, I hope not, but in the future, if there is some kind of emergency, at least we have some ways to not to stop the justice and not causing this backlog. That will be like a good way, a positive way to see it. Now I would like to switch to the most important, I believe, part of your presentation for us as Latins. That is the cases, because at least in streaming, if you see Latin America, we don't have that much case law in comparison to the rich case law that we can see in the US. So welcome to start your case law presentation.
Okay, thank you, Jose. Here we are. Are there recent cases in which streaming services have enforced their rights? The answer is yes. And I'll give you two examples, one from the video streaming field and the other from the music streaming field. So just a month ago, in the Central District of California, which is the federal court sitting in Los Angeles, a number of internet streaming services succeeded in holding accountable an unauthorized streaming service called CCM. In this case, Disney Enterprises Inc. versus TTKN Enterprises. Disney and other streaming services such as Netflix and NBC's Peacock and others brought suit against an unlicensed streaming service. It was really an important result for the legitimate streaming services. The case was filed in August, but by November, the streaming services had obtained stipulated judgment against the infringer on three grounds of liability: direct copyright infringement, meaning that the activities of the defendant were directly infringed the right of public performance. The plaintiffs also obtained judgment holding the defendant liable for contributory copyright infringement, meaning that it had knowledge that it was providing a service that individual users would use to infringe copyright by viewing unauthorized streams. And then finally, the plaintiffs obtained judgment against the defendants on the claim of inducing copyright infringement. That requires showing that the defendant actually promoted its service for the purpose of infringing copyright and that promotion was directed toward the individual users of the service. So that was, a very favorable result on the law. The remedies were considerable. First of all, the court granted the streaming services a permanent injunction, and the defendants were prohibited from operating their streaming service for unauthorized public performance of videos. The court also required the defendants to transfer ownership of their domain names to the legitimate streaming services. And the purpose of this was to inhibit the defendants from resuming their activities under other domain names, and also to inhibit these domain names from becoming available to other prospective infringers. Finally, there was really a significant award of damages made by the court. The defendants stipulated that they would pay the streaming services $40 million in damages. Really an eye-popping number. And for those who are skeptical that the streaming services would ever be able to collect $40 million from the infringers, the plaintiffs had an answer to that. They asked the court to impose a constructive trust on the defendants. And the effect of a constructive trust is to prevent the defendants from transferring any of the money they have received or will receive, and to require that that money be used to pay the damages before it goes to any other expenses. So, a significant victory. The lawsuit was coordinated by an alliance of internet streaming services, much like Alianza in Peru, and it's called the Alliance for Creativity and Entertainment, and it includes streaming services as well as the motion picture studios and other video producers. This victory followed up on a 2019 victory by the same plaintiffs against another unauthorized streaming service called Omniverse One World Television. And the damages awarded in that case amounted to $50 million. So important work being done by the Alliance in the United States as well in protecting the exclusive rights of streaming services. Okay, turning now to music streaming. At the end of November, the record label Atlantic Recording Corporation won a victory against an online service and music streaming service called Spinrilla. This case was brought in the Northern District of Georgia, which includes the city of Atlanta. The court granted the record label's motion for summary judgment on its claim that the unauthorized streaming of sound recordings by digital audio transmission infringed the exclusive right of public performance. The court also denied the defendant's motion for summary judgment on its defenses. First of all, that its activities did not constitute copyright infringement. And its second defense, that it was entitled to a safe harbor under the Digital Millennium Copyright Act. The defendant had argued that they were only hosting infringing sound recordings that had been uploaded by users. And under those circumstances, the Spinrilla could not be held accountable for the activities of subscribers unless they had very specific knowledge of the infringement. The court dismissed that defense. So this case will now proceed to trial on the as well.
Thanks, Mark. This updated case log is really interesting for us. As I told you, in Latin America, there are not many case law, and so for us, it's really good news knowing about all these provisions and this updated case of Atlantic recording in the music industry, especially for all these service providers like Spotify, Deezer, and all these that are like the trendy ones. It's really good to know about this. We are running a bit out of time because we will have 15 minutes left, but I will let you finish your presentation. The next topic is about the clearance of all the licenses and permissions that usually your clients have to take when talking about streaming. So feel free to just to enter your presentation, and in the end, I think that we can give 5 minutes of questions.
Oh, I will try. Thank you, and I'm sorry I'm running over. I will actually, I can actually summarize most of this. The second part of my presentation is really, directed at sort of the challenges that streaming services have in managing clearance of rights in their programming. So streaming services may incorporate copyrighted works created by authors, composers, producers of phonograms, or performers, and their streaming may also implicate public performance or reproduction of the works that are comprised by their streams. So clearance becomes an important issue for streaming services too. Here's this slide just provides a table on sort of in general what rights streaming services need to produce and stream their programming. And I've separated the table out into types of content, the rights needed. Again, those rights are described as they would be described under US law. And then the usual source of obtaining authorization to use that content. So I'll leave that for you to for participants to look at in their at their leisure. Let's go right to developments. There are developments in legislation for clearing rights in streaming programs. Last year, the United States Congress enacted several new laws that address protection of exclusive rights in copyrighted music and in sound recordings. I'll discuss two of those. The first is the Classics Protection and Access Act. This legislation provided some new remedies for sound recordings that were first fixed before 1972. One of the peculiarities of US copyright law is that recordings made before February 1972 are not protected under federal copyright law. This, of course, comprises that time period includes the age of classic rock and roll and progressive rock, and so there's a lot of very valuable sound recordings that are not protected by federal copyright. Instead, they've been protected by various state laws in New York and California. The Classics Protection Act takes a step forward toward providing some legal remedies for unauthorized use of those earlier sound recordings. It provides a term of 95 years from first publication, plus a variable transition period for these sound recordings. it brings these sound recordings into closer status to sound recordings made after 1972. And at the bottom of the screen, there's an important element that the Classics Act extended to pre-1972 sound recording, the existing statutory licensing system of public performance by non-interactive digital streaming. Okay. So there has long been in the United States a statutory licensing system for publicly performing sound recordings on non-interactive digital streaming services. And now these earlier recordings are now in that system. That means the record producers are able to participate in royalties. It also means that streaming services will have the benefits of safe harbors by participating in the statutory license. The second piece of legislation is the Musical Works Modernization Act. This does not affect sound recordings, but it affects musical compositions, right? And it does not, under earlier US law, there was a compulsory licensing system for a mechanical license, meaning a license to reproduce musical compositions in phono records. Right? That system is, remains in effect for non-digital media, such as CDs and vinyl phono records. But for all other uses, the Musical Works Modernization Act provides a system of blanket mechanical licensing for streaming services to make and distribute digital phono record deliveries of copyrighted musical compositions. Right? That's very useful for the streaming services. A blanket license means that all of their use of musical compositions can be addressed in a single statutory royalty payment system without having to engage in voluntary licenses if they do not want. This legislation also created a new collecting society to receive reports, collect royalties, and distribute royalties to copyright owners. Right? And has very high standards for transparency stipulated by Congress. Here's an important point for composers and music publishers outside the United States. All music used in the US is eligible for a royalty distribution under this law. So both US songwriters and publishers and non-US songwriters and music publishers should register with the Mechanical Licensing Collective. If the Mechanical Licensing Collective cannot identify you, then you will not receive a royalty. But if you join, they will you will be identified and you will participate in the royalty stream from music streamed in the US. Okay. And performers' rights remain largely the same. They're very limited. There's a federal anti-bootlegging law that prohibits unauthorized fixing of live musical performances in sound recordings and music videos. There's no analogous law for performers in audiovisual works. Those are governed by contract and labor union collective bargaining agreements. There is one notable development. In November, the two unions that represent film and television actors and the other union that represents live stage actors reached a temporary agreement. And this enables live theaters, to record and stream their performances of theatrical and dramatical works over the internet under certain circumstances without breaching the agreements with the unions. It also permits the stage actors to engage in this activity without violating the terms of their own union regulations. So that's an important temporary measure to try to save live theaters during COVID-19. Okay. And aside from a few closing thoughts, that's the end of my presentation. Jose, thank you, and thank Giancarlo for bearing with me.
Thanks a lot, Mark. It was really a pleasure to have you and to have Gianmarco here today in this panel. Sorry that, as always, time is golden, and we will need more time to finish all the topics that we were planning. But I would just like to throw one question by Luis Díaz from Peru. I will try to translate it to English as it is in Spanish, and it is the following question. What is, for anybody of you, what do you think about the possibility of doing a project between a CP, doing a project between a CP and Alianza in order to promote work in urbanization and exchange of information in order to unify criteria for the copyright offices, or etc. There, the main idea of the question is to work together with a CP and Alianza to work together on this field, on these topics.
Gracias, Jose. I'm going to switch to...
Thank you, Jose. I'm going to switch to Spanish. I think it's a better idea. It would be of great benefit, really. Anything implying, well, the importance of a CP as an organization, I think that it is quite beneficial. That is, promoting exchange, not only of ideas, but efforts to unify criteria in this fight against piracy. Really, the question by the participant is excellent. And it is true, we should explore potential paths to work together. And I think in Peru, the Alianza Against Piracy has been working very well, and maybe we should analyze future steps to coordinate work. So it's good then to
Mark? Do you have any thoughts?
Mark, did you hear the question?
On this regard?
Oh, I did not hear the question. Can you repeat it? Or?
No, that the question was mainly about working together between a CP and Alianza in these fields, in order to harmonize law or projects in that sense. That was the question. In case you have comments, yeah.
I don't want to commit Giancarlo's organization to anything, so I'll leave that up to him. But the one thing that I would say is that 20 years ago I did work in anti-piracy efforts, and public communication is really an important aspect of this as well, because if we can change people's expectations about how to respect copyrighted programming, that helps with other enforcement efforts against bad actors.
Okay. Well, thanks, Mark. With this, I think that we can close, because I know that at 1:30 the system will shut off. So I think that we at least make one question. I know that there were some questions, but we cannot do it because of the time. But thanks a lot for participating today, and it has been a pleasure.
Thank you, Jose. Listen, as far as the people who have questions, they're welcome to send me an email if they like. I'd be delighted to answer them. And
that's great.
And thank you, Jose and CP, for the opportunity. Thank you so much.
Okay. So see you in the closing reception.